Well, at this point, I'd just like to say that your fucking court is a joke. A joke, and you are.
Okay, we are 5 seconds in and already off to a flying start. Imagine walking into court and calling it a joke, to the judge's face. This isn't just bold, this is burn the bridge on arrival energy. Not exactly the best way to win sympathy from the bench, folks.
Hearing your fucking self.
Sir, you are on the record, and this is a court of law. That's not acceptable.
Well, Your Honor, John Goldwell, P30758 on behalf of Mr.
All right, Mr. Huff, your name for the record, please. You're muted.
Oh, I'm sorry. Nelson Hout.
Okay, thank you. And thank you for dressing appropriately. Shuts up that we can see each other. 2 things. One, your client is here for sentencing and his plea to an amended charge of disorderly conduct. I don't see Kevin Hamilton or Jeannie Tackett here. However, the court can still proceed in this manner.
That's correct, Your Honor.
And there's also the request is to handle this on the record as well regarding use of marijuana.
The classic marijuana on bond dilemma. Quick legal note here. Even if marijuana is legal in your state or you have a medical card, using it while out on bond can still land you in hot water, especially if it wasn't pre-approved by the court. It's like bringing wine to rehab. Technically legal, definitely frowned upon.
While on bond. And counsel, as to the sentencing.
As to sentencing, Your Honor, you indicated use of marijuana while on bond. I'm aware of that.
Well, so Mr. Houck had submitted proof of the medical marijuana.
Oh, that's correct.
And he had one prior to the agreement. It expired, so then he renewed it during the arraignment or during bond phase. And so my thought was that we would chat about that today.
Oh, okay. I saw that in the. I wasn't present to this one. Fine, Your Honor. We've had an opportunity to review the pre-sentence report in this particular matter. Your Honor, this has been an ongoing matter. It's been a lengthy negotiations. Matter occurred back in September of 24. I reviewed the video of the arrest. I filed a request for the video of the incident, and we were informed that the actual video of his time at the McDonald's was no longer in existence. We discussed his involvement in this matter and the reasons why this occurred. As to the general background information, as you can see, Mr. Howell has not had an easy life. Some of it is of his own doing, some of it is because of the early stages that he went through. Ended up with the being
This moment highlights something we hear all too often in court: a rough upbringing being used as context, not excuse, for adult behavior. The legal system isn't just judging a single event, it's sifting through someone's entire life story to understand why they are where they are. That doesn't always sway a judge, but it can shape sentencing.
And I apologize, Your Honor. He's been diagnosed with behavioral problems, clinical depression. His parents never married, and he became a ward of the state at age 7. I'm sure the state did as best they could. However, the court is well aware that's not the best of all circumstances. He did complete high school, however, he did not graduate, and he received his GED. He also indicated that he has a paralegal certification. Trust me, my discussions with Mr. Hauk, he's clearly learned a great deal during his paralegal training. He's indicated his health is decent. He's on parole, has been for approximately 3 years. His parole officer is aware of all of this going on in his life. I did not speak with the parole officer, but I did carry on some other conversations with Mr. Howard regarding that. To be honest with you, Your Honor, and I know he was just a statement, as you can see from his statement, he was at McDonald's. He was there to pick up some food. That's why he was in the area. Things got out of hand. He felt that he was being mistreated. I guess one thing leads to another. When you review the body cam, it's clear that when the officers arrive, he is attempting to tell them what really happened there, asking, hey, I need my witnesses. And they're just saying, well, no. And they're just responding and making an arrest, whether, it's clear enough, but he was. And you can see that what occurred and what triggered the incident in McDonald's. And I'm not saying he's not taking responsibility, but in his mind at that time, regarding whose fault it was or whose fault it wasn't, and as you can see from his statement, the long story short is I was in the wrong, and I think, Your Honor, that this all carried over. And so I know that the recommendation is for incarceration. He's had 3 children. He has a 4th on the way. She's pregnant. And I know she's pregnant, and she's due in about a month and a half. He is not employed at this point in time, though he is still going out working. As, again, one of the things on his parole was, as he told me, for 3.5 years, he hasn't violated. His probation officer has not found a reason to violate, which is good. And I'm not suggesting. In fact, he's told me he does not believe that he'll be violating parole on this one. However, Your Honor, I'm asking the court place him on probation. He does have another matter that's in Lansing Circuit Court. His parole officer is also aware of that, and as he's indicated to me, that's set for hearing, and they're aware of this matter as well. He's on probation not probation, on bond out there. He's on a tether out there, and he's in full compliance out there. I don't believe that incarceration at this time would be the appropriate remedy. He is the sole child care support. He's trying to get SSD. That's under appeal. And as he told me, what he's trying to do, Your Honor, is to, he also is attending mental health treatment, and he's trying to get better. He recognizes his past and recognizes that he cannot continue that way, and he's trying to move on. I don't believe that incarceration at this time would be beneficial to anyone.
Well, what would you suggest, counsel? Because the individual in this matter, first of all, the way that I would view the facts of this case is that Mr. Howe was dissatisfied with the time it took for him to be served or to pick up a mobile or whatever it may be. So he decided to then go behind the counter himself to get his food. Then proceeded, when an employee was attempting to prevent him from doing that, proceeded to assault that employee. Now, your client also, in addition to his lengthy criminal history going back to 2008, has a number of assaulted crimes. Currently on probation, on parole. And he's also out on bond on another matter prior to this matter.
That's the question. Yes, sir.
I understand that.
No, I'm just.
But for parole to not violate Mr. Howe based on this incident and this behavior, and for a bond violation to not be occurring, I'm not sure if it's occurring actually, I don't know if that occurred, but also for parole violation to not occur on the Lansing matter.
And there it is, the prosecution painting a very different picture. A mobile order, a customer crossing the counter line, and alleged assault. Here's a question for you. If the customer really believed he was in the right, was taking matters into his own hands justified? Or does that cross into vigilante fast food justice?
I have serious concerns for the safety of the public and individuals in general, given Mr. Houck's tendencies for violent behavior. This was over a mobile order for food, and Mr. Houck was tasked by his boss to go pick up. This matter was scheduled for jury trial, and quite frankly, the prosecutor at that time thought that it was in the best interest of justice to offer this matter, or this plea in this matter. And quite frankly, I don't see how I have a choice other than jail for Mr. Houck. Because the purpose of probation is to afford somebody an opportunity to learn from their behavior, fashion conditions to help them modify their behavior. I have zero rehabilitative conditions that I could offer to Mr. Houck. Zero. I have zero confidence in any of the conditions that I would typically put forward for somebody in a matter like this. That any of those conditions would be rehabilitative. At all. Mr. Houck, I am flabbergasted that you thought that it was your right to go back behind a counter of a place of business that you are not employed. And then, when somebody attempts to stop you, you assault them.
Ma'am, can I speak? Are you asking me as far as opening the floor for me to speak?
Sure.
Okay, well, ma'am, I think you're misinformed on the incident that happened there. And that is why, if the video would have came out, it would have showed the true actions of what happened there, ma'am. And I don't know where you're getting the information of. I was upset about how long it took or anything like that. Ma'am, that is not accurate information at all. There is a police call. There was video evidence. You would have heard all these things if I went to trial, ma'am. But the video was somehow lost. 14 seconds of another video to show two heads popping in was found, which is mind-blowing to me. And I'm flabbergasted that justice isn't thinking, where is the evidence? Why was not evidence preserved at the time of a crime that you said you seen me commit from a video image? So why was it not preserved? That is the flabbergasted part to me, ma'am, that you are condemning me in your head already off of facts that are not true. There's no factual basis for what you're saying, besides word of mouth. And anyone can write down their version of the story. Ma'am, and I know, ma'am, there's 3 versions of every story, but one version doesn't lie, and that's video evidence, right? And somehow somebody scrubbed the video evidence because they didn't want the truth to come out, ma'am. So,
Sir, pause just a moment. I don't know if anybody scrubbed any evidence or Sir, if you'd like to make a statement that video evidence isn't available or whatnot. You don't know what happened with the video evidence. I don't know what happened with the video evidence. I don't even get the ability to see the video evidence unless it's submitted pursuant to the rules of evidence. And since there was a plea in this matter, that never was
I would
an
love
issue.
to go to trial
And
again.
excuse me. As far as where I'm getting some of the information, some of it's in your own statement, sir, regarding you were ignored for around 5 minutes. So that was in your own written statement.
Ma'am,
So
in my written statement, I confirmed that I stood in line waiting. I stopped a different worker, not even the worker I got into an altercation with. I stopped a totally different worker and asked her a simple question of, hey, when does these numbers and I didn't say it with aggression. I didn't say it with irritation. I said, hey, can you please tell me when do these numbers transfer over to these numbers so I can get my order in? I said, I already paid for the food. It's already done. And before he could even answer, the person who I got into the incident with came rushing over, intervened. What's going on here with an attitude? I didn't get an attitude back. I just explained the same thing to him, ma'am. I showed him the picture I had. I showed him the screenshot I had that confirmed the order was already paid for, confirmed everything was done. I didn't even need to even come talk to nobody for real, ma'am. All I had to do was be handed a bag and go, right? So I didn't go in here looking for an incident, ma'am. I did not. This is not like a
I didn't say you went in there looking. Sorry, I didn't say you went in there looking for an incident.
No, but you said I'm in there violent prone, ma'am. You're trying to paint a picture in your words. You're trying to paint a picture of this big violent person, ma'am. Do you know how long it's been since I've been accused of a violent crime besides this one? It's been years. I have been working on. Yes, I've had a violent past. Yes, I've had a history. Ma'am, I was taken from by the state at the age of 7. I was raised in placement homes and lockup facilities. I was never given a chance at true life. I was given the chance at being a caged animal. So then when you ask me, am I prone to violence? Yes, sometimes I do have what I'm diagnosed with explosive behavior, ma'am. And that's only when pushed. All my violent record I have is assault and batteries. All those are from being locked up facilities, fights in a lockup facility. None of those are from street altercations, being in the real world altercations, ma'am. So I am not violent prone like you think I am. I was in a cage situation with other violent people, and situations became violent. I learned not to allow myself to be a punching bag to other people. Yes, and because I did more damage, I got charged, ma'am. I can't help that.
Sir, you're matter out of Utah in 2018.
Yeah, 2018. How long ago was that, ma'am? How long ago was that? 18. This is 20. We're going on 26 now, ma'am. That's
Sir,
years.
Sir,
That's years.
At the time of this incident, that had been 6 years. So
right, 6 years since I had a violent outburst.
That was aggravated assault resulting in serious bodily injury. Was that,
yes, ma'am.
Were you in custody during that offense?
Was I in custody during that offense?
Yes.
Ma'am, even on that case, there was never no evidence. I pled out because I was in prison for 3.5 years fighting the case already. So it just made more sense to go home, right? Take the deal that was offered to me and go home. And that was one of the cases on the deal. Ma'am, I didn't get caught on this crime at the scene. I got caught on, they reported this crime 2 months after this alleged crime happened. Ma'am, you're speaking on something you do not have the facts to, ma'am. You do not have the facts to these things. So you're still you're trying to justify in your head why you want to give me incarceration, which is not in the interest of justice to incarcerate me because there are mitigating factors to this case that you are not even taking into consideration, ma'am. You're not. All you have said since you said something to me is about, oh, he's this, he's a menace to society. Ma'am, I did not go. This was not random. I was a working father at work who was denied his food because of the color of my skin, and it was noted in the phone call that he made to dispatch. If you heard that phone call when he said it's a black and he threatened my life, come quick. And I never once, in fact, threatened this man's life. In fact, ma'am, I asked him multiple times to take his hands off me before I even touched him, ma'am. Before I touched him, I asked him multiple times to take his hands off me. I informed him he was committing assault by putting his hands on me. Unwanted touching of any person is assault. Okay. Assault does not have the right to put his hands on me, no matter what you say.
Mr. Howell.
Yes, ma'am.
You entered a plea
Are you justifying that he has the right to put his hands on me, ma'am?
Sir,
He has that right? Can you clarify this for me? I have it on record, please.
listen, that matter is not before the court for this court to make a
Hey,
determination.
you're damning me off of.
Excuse me. Excuse me.